Um, GPS device is for, you're talking about the GPS device.
Yes.
There's a reason for that in cases like this. This is injury to a child. It's alleged he punched out the 6-year-old. So the GPS device is to ensure that he's not around children.
I understand that, Jerry.
And if something bad happens, we'll know who was there. And there was no victim contact. I mean, that's why the GPS is just, it didn't come out of the sky. It's because if you're going to punch out a 6-year-old, according to this probable cause affidavit and the grand jury indictment, you're looking at me or him, or are you paying attention, or is this boring to you?
No, I'm listening.
All right. Here's the grand jury who's accusing you, not me. Here's the grand jury. They thought that there was an investigation, and family services was involved. The child made outcry to someone, then was at Garth House. Police investigated, and the way America is, and the way we look at taking care of children when children are at risk and are harmed. This is a state jail felony, which carries with it up to 2 years in the state jail. It is a felony. We treat it seriously. That's what the GPS is all about. Is if he's going to do this to the child, children are at risk until we can ferret out what happened here and determine whether he's unsafe for others.
I understand.
That's why it's there. Yeah, that's why it's there. Franco. All right, we'll call 23 CR 2241. You're reading on it.
Yeah, I read
You
it.
can't read this. This is
It's a private accommodation.
no.
I realized I did the paperwork for a second degree. It's a state jail felony. I thought it was done under abandoning, which is a second degree, but I was thought it was a state jail or
State jail.
I filed it. I thought it was second degree. It's abandoning it.
I didn't even look at it.
Yeah.
So
Abandoning it is normally a second degree, so I did it on the wrong paperwork. Well, so we do it with
Here's what we're gonna do. I can write it in.
It's got the
other. It's got the other
That's fine with
punishment
me.
range, and we'll just
That's fine.
erase the second degree and then write in state jail felony. How's that?
That's
Is that good for everybody?
good with me.
yes, Your Honor.
There's just one difference. It's different. We should not. That's a good thing. So.
Getting the printout for that. Sign that, please.
It's makes it better for you. It's not right shares.
I found, strangely enough, that's the year starting off great. Some Lifesaver gummies, the gummy Lifesavers on sale.
Oh,
Your lucky day, huh?
Yeah,
I'm surprised you didn't buy the store.
I bought all they had. There were two bags. And there. How we doing?
It says it stopped responding.
Well, a lot of the lawyers in this courtroom
He's not
have
responding.
the same, are showing the same
Yeah.
message. Well, should we call MIS? See what happens when I say that? Call the principal down and all of a sudden
That's.
I'll give you two. Right?
Your friends are all right.
Possible.
Maybe.
Thank you.
Give it another whirl. So how would you do two?
Got sidetracked. Do the audit mode.
All right, everybody, look at this as an initial punishment range, if that's correct. No less than 180 up to 2 years in a state jail. And fine up to
Your initials.
So 23 CR 2240 is now called. The state of Texas versus Lilia del Carmen Franco. You are Miss Franco. You have to speak out. Report. Yeah. And you were here with your attorney, Mr. West, and the state's attorney. Thus, the defendant waived a formal reading of this indictment handed up by the grand jury on December 13th of 2023. Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about November 6th of 2023 in Jefferson County, Texas, you committed the state jail felony of abandoning or endangering a child one way to write the caption, but I don't think that's. Abandoning or endangering a child, elderly individual, or disabled individual. It says endangering child individual with intent, but it's, anyway, it's, in this case, it involves a child younger than 15 years of age. Do you understand what you're charged with? Because this is a state jail felony, a serious offense. If convicted, you face no less than 180 days and no more than 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 5 years in length, fined $1,000. There will be terms and conditions of probation, which are normal and customary, including a parenting class that we have available. And Then this says 100 hours of community service is written in there. Why is that?
That's the.
Because we're going to have community service and what
Does
is
it,
it normally?
it's the terms that the attorney negotiated. Jeff.
No, no. It's going to be normal and customary, but also those are terms that we can adjust for good behavior while on probation. But it's a non-binding recommendation. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to the state jail felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty of what this alleges.
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Did you understand it? Discuss it with your attorney or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objections?
Or without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
It is, Your Honor.
If nothing further, I can move forward now and find if no objections, we will move forward and the court will make the following findings. That Ms. Franco, you were pleading guilty today voluntarily. You're mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in this hearing to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and postpone so long as you follow the terms and conditions of probation. And they will be here. They will be read to you and reviewed with you by the probation officer in a moment. You must pay a fine of $1,000. You'll be completing a parenting class. There will be other terms and conditions of probation, which are normal and customary. Make sure you follow them. If you fail to, your probation could be revoked. You could then be found guilty and sentenced up to 2 years in the state jail. So follow the rules.
Your Honor, the only other issue I had to bring up is I've been speaking with her CPS caseworker involved in this because obviously CPS was involved. The judge has indicated that as far as her visitation and return of the child, they said it was kind of up to you if you had an objection to it, but otherwise, if you didn't have an objection to that.
The probation office will be conducting a post-sentencing report, and we're going to see where that plays out because they're going to be best able to help me make the correct decision on that.
But I said
But
the family.
right now, we're all frozen. Everything is frozen. The status quo remains until the court sees the post-sentence report. And if there is an issue after that, then let me know.
Right. Like I said, the CPS said there was no issue, but they wanted to make sure everybody would be first. So
Probation office does a great job of uncovering any other matters that sometimes are overlooked, but I wouldn't be surprised if that's what they say. And, I wouldn't be surprised if the probation office confirms that prediction. Okay, thank you. But we're going to hold off. Andrew Perez.
Adam?
Hold on, I'll be at the bottom.
I want to get getting on this in 30 days. It's only like 30 days. We'll just meet up. Okay, we'll get with you and
Terkees Henderson, I'll bet.
It's Adam. It's not right there.
Here's here is Adam Curtis, right there.
I'm gonna keep calling you Dave.
Terkees, Henderson is called 23 CR 1761.
You leave that.
I want to make sure you, you're charged with the state jail felony of driving while intoxicated with a child passenger. You have to, I guess you have an interlock device in any vehicle you operate.
Do you need the device now?
What'd you say?
No, Judge.
Are you driving?
Yes.
Did you drive? No. What the heck?
Did you have a bond condition on it?
Yeah, that's a bond condition in every case. It's written on the wall in there. Well, your bond, who's your bondsman?
Valerie.
No, Al knows better than that.
I'll make sure she gets official.
Oh, she has to have it. You drove up here, I'll bet, right?
Yes.
I'll make sure she gets
Yeah.
a ride home, Judge, and then takes care of this immediately.
I can call him on to pick me up. No problem.
You need to get it taken care of no later than tomorrow.
You have to have an interlock device. If that's, it all depends on alcohol and our own. Okay, what was the blood draw?
Came out
Okay.
0.186, Your Honor. So
Oh, alcohol.
Yes, sir.
Okay.
I'll instruct her on where to go get that today. So this kind of keep on for installation.
I mean, you know, these are the kinds of things where somebody gets on a frozen day, somebody slides, hits somebody, and then they happen to have alcohol on their breath, and then they're on the front page of the news, it's who's to blame. It's not necessarily the defender at this stage. How much is your bond? What was your bond? I don't have anything.
I'm not sure.
What was you posted a bond of some sort? 8,000? How much you have to pay? 800? 10%?
No, it should be like 250. Well, it's not so.
I don't have it in my record, so.
I have the areas. I have the pistol at home.
I don't have a copy of your. It was 8,000, Your Honor.
All right, please, here, hold this and put us, we're gonna call Al later. Al Reed and find out what happened on that and why that didn't get occurred. All right, the marching orders are, you can't operate a motor vehicle without an interlock device, period.
Okay.
You've been given notice, you do. Your bond would be revoked and you would be on house confinement until this case is disposed of, okay? Because this is serious. It was a 4,000-pound missile. And we have too many cases where DWIs result in deaths. So fix that, okay? Thank you.
Get a reset on this later.
And
Setting. Oh.
how long are we doing the resetting?
Oh, I'm sorry, 30 days, just.
30 days, thank you.
Just need to look at something.
Johnny Howard?
I'm on the X one with these man.
I need Johnny Howard, please. Johnny Howard, is he in custody?
No, Judge, he's outside. He's across the road out there. In a red sweatshirt. There he is.
Yes. Okay, go ahead. So you want,
Yes, Your Honor.
by the way,
I'm sorry.
we called cause number 23-41401, the state of Texas versus Johnny Howard, and you were the second.
Yes.
And you were charged with the state jail felony of injury to a child. And go ahead.
Yes, Your Honor. I'm filling in for Mr. Bruce Smith today, and he previously had filed a record. Defendant's motion to modify bond restrictions, asking for the ankle monitor to be removed at this time due to the defendant not having any issues up until this point, and it being a financial hardship on the defendant while he's looking for work, Your Honor.
GPS device is for, you're talking about the GPS device.
Yes.
There's a reason for that in cases like this. This is injury to a child. It's alleged he punched out the 6-year-old. So the GPS device is to ensure that he's not around children.
I understand that, Jared.
And if something bad happens, we'll know who was there. And there was no victim contact. I mean, that's why the GPS, it didn't come out of the sky. It's because if you're going to punch out a 6-year-old, according to this probable cause affidavit and the grand jury indictment, you're looking at me or him, or are you paying attention, or is this
Yes.
boring to you?
No, I'm listening.
All right. Here's the grand jury who's accusing you, not me. Here's the grand jury. They thought that there was an investigation, and family services was involved. The child made outcry to someone, then was at Garth House. Police investigated, and the way America is, in the way we look at taking care of children when children are at risk and are harmed. This is a state jail felony, which carries with it up to 2 years in the state jail. It is a felony. We treat it seriously. That's what the GPS is all about. Is if he's going to do this to a child, children are at risk until we can ferret out what happened here and determine whether he's unsafe for others.
I understand.
That's why it's there. Yeah, that's why it's there. I'm sorry, why, I'm reading this. The essence is under paragraph 4 that you sent a transcript and they wouldn't accept it.
I hand deliver it. They would not accept a thumb drive in which we now get the transcripts over computer. I could see why they wouldn't want a thumb drive.
Well, can we make a copy of it?
I brought this down to the county jail and they said I couldn't do it.
Why did they say that? Did they give a
Some
reason?
lieutenant said, wait till he gets to TDC. Well, there's a pending case here. So he's not going to TDC. His brief is due February, mid-February. And all I need is for the court to say, I can hand it to him because he needs to review it.
I don't see any reason why, unless there's something at the jail that I'm not aware of. I mean, they didn't explain why.
No,
Well, I'm not sure what you can do, how you can harm other inmates with a piece of paper. We send them back with papers all the time.
Not to that width.
well, that's the reason why I handed
Here's what you need to do, was put that in a rubber band or something.
Well, I've got a rubber band.
Now give it to him.
I didn't think that they wanted a rubber band, but I will give it to them.
No? Otherwise, you got, how many pages there?
490.
Well, they're gonna go all over the place if they're not attached somehow,
There you go.
but you're handing it to him. I'm ordering him to accept it. He's accepted it without an order. And that is something you are requiring him to read.
Absolutely, Judge, and I'll be out.
And there'll be a test on that later.
I'll talk to him.
Okay, if there is a problem with you maintaining that documentation, they take it away from you for whatever reason, alert your attorney, then I'll be back in the game. But I'm ordering you to accept it, and unless the court can understand and appreciate and hear that there are rules from the jail because of good reasons like safety or security that prevent this from happening, we'll have to review it again, but I don't understand. I don't foresee a problem.
No.
All right. And that's done. 23 CR 99 is called the State of Texas versus Michael McCray Duncan. You are Mr. Duncan.
Yes, sir.
Present with your attorney, Mr. Galmore, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in sight?
It does.
In summary, this indictment alleges that on or about September 30th, 2022 in Jefferson County, Texas, you operated a motor vehicle on a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more DWI convictions. Paragraphs 1 and 2 constitute a third-degree felony if found guilty. Do you understand?
Yes, sir.
A third-degree felony carries with it, if convicted, a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached between the parties. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on probation for 10 years. And there will be, and also as a condition of probation, you must spend 10 days, right?
We made an agreement for 15.
Hold on, under the law.
That's correct, Your Honor.
You must spend at least 10 days.
Yes, Your Honor.
In the county jail as a condition of,
Yes, sir.
it could be up to 180 days. But the law says at least 10
Yes,
days in the county jail. And there's a non-binding recommendation that you would be ordered to perform 15 days in the county jail on weekends, which would, you only get 2 days credit. So that would be 7.5 weeks. 8 weeks. You would have to serve that last week, only 1 day. If my math serves me.
That's correct.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? How do you plead to paragraphs 1 and 2 in this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
And paragraph 2 of the indictment, which alleges these prior convictions of on February 8th, 2013 in County Court of Chambers County, Texas, you were convicted of a DWI. And also on November 20th, 2013 in County Court of LawTube of Jefferson County, you were convicted of another DWI. Are those allegations in paragraph 2 in this indictment true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily? And because it is, those allegations are true.
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney? Or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, it states, so help you God. Is that so?
Yes, sir.
And Your Honor, just with regard to restitution, there's potentially a small amount that's still owed. I know there was a settlement between the individuals who they were the back of their vehicles ran into that they I know they settled most of, if not all, of the claims, but there could be still a small amount out there. So potentially, once I speak with the party to determine if there's any, I'll let probation know the amount.
So restitution is ordered in some amount that the parties agree will be determined by the post-sentence report in the probation office. Is that right?
Yes, sir.
Okay, that's correct.
Yes, sir.
All right. Because by law, restitution has to be ordered at the time of sentencing. That was a very important issue in a very important case that was taken up on the Court of Appeals out of this court, which we had followed. But it was one of those which had to be determined. And they said that was, as long as restitution is ordered, in an amount to be determined, then there's a period of time, a reasonable period of time where it can be determined, and then that order of restitution would be carried out as part of the judgment. If nothing further, I'm going to find you are pleading guilty and true to paragraphs 1 and 2 respectively of this indictment voluntarily, knowingly, intelligently. There's sufficient evidence supporting your plea of true and guilty from State's Exhibit 1 admitted here to support all of your pleas to find you guilty beyond a reasonable doubt, as I find that you are pleading guilty voluntarily, knowingly, intelligently, and because that is what you wish to do. I accept your plea, find you guilty beyond a reasonable doubt of this third-degree felony of operating a motor vehicle in a public place while intoxicated, according to paragraphs 1 and 2 of this indictment. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That term of 10 years confinement shall be suspended. You were placed on regular probation for 10 years. There is no fine. However, restitution shall be ordered in an amount that is what is agreed upon by the parties, that is not covered and already fulfilled by insurance reimbursement. Do we know about what it is?
I know last time when I spoke with,
What was the
there,
total
I think it was around $1,300, but
What was the total amount that the insurance was? That
I'm
was
not sure. I know there was an indemnity agreement. They settled out all the claims of it. I know that's what the victim in this case told me, that I believe there's roughly $1,300, but that was still waiting to be settled out.
Roughly $1,300 what?
In restitution. It was medical bills, I believe.
That's still unreimbursed?
That was correct, but again, I need to update that and see if that was settled or not, because they were settling with his insurance
But
company.
there was an amount that
A small amount, yes, you're right.
That was that is reimbursable somehow in one way or the other to the victim in this case, or the complainant.
Yes,
Correct?
yes.
Everybody agrees. Right, then you're nodding your head, Dustin. This court is ordering restitution and amount to be determined by the post sentence reports. If there's an issue on that, let me know. We'll deal with it. There will be other terms and conditions of probation, such as a DWI repeat offender program. You okay? All right.
Alex.
366 in Honolulu. I used to jog there when I was a little kid. I lived right off the Honolulu. And 366 was a major intersection. There was a chemical company that was right there at that corner, right across from, it's Huntsman now. That was Jefferson Chemical, but across the street from there, would have been the south side of 366 was a small company that was boarded up and fenced off and had all kinds of security around it that the United States government had. They made Agent Orange.
Interesting. You didn't know that.
Yep.
Yeah.
Anyway, that's what I know about that intersection, but it's a major intersection. What was the alcohol content on this event? Y'all know?
0.316.
Good Lord. You need, hello, unless you've gotten a grip on it, you need some help. 0.30?
316.
316. Well, that's 4 times the legal limit. Do you see anything wrong with that? What are you doing? Because operating a motor vehicle while intoxicated is a very selfish thing, you know. Because everybody is at risk. I'm gonna roll everybody's eyes, but this is a 4,000-pound missile you're operating and you're high as a kite. Too often people come in here who have been seriously injured or killed, and there's nothing more sad than those people wondering how that happened to them or their child or their relative when they were following the rules and someone was operating a 4,000-pound missile recklessly and out of their mind. It's a very selfish thing to do. We have to share the road with everybody. But you have to appreciate the next person's life, that you care. If you don't care about yours, which would be foolish, you need to care about all the people who are trusting other drivers to be responsible. But we see it over and over again, and it's catastrophic. I mean, it's gruesome. And that's the case where we have more people weeping in this room, wondering how that could happen. I mean, you got to get a grip on this. This is your third time, but and you were in an accident here, a collision here. Well, you're lucky. You know, people go to prison if someone is injured or killed generally in a DWI. And if you're killed, we've tried in my 17 years here, we've tried 5 or 6 jury trials. Every one of them received 20 years max. Every one of them, the jury did that. So I can have a sense of what the people in the community think of this. We know people drink. We know they drive. But if you kill somebody or seriously injure, the 12 jurors who sit over there have no sympathy except for the victim. 20 years maxed every time. We haven't had a jury verdict less than the maximum. That's how serious it's thought of universally. Scam. Well, you got 250,000 people who are frowning on your behavior. So you got to fix it, or you'll be held accountable. Now, here's. Doesn't say anything about what happened to the other driver. What do we know? What do we know?
As far as the driver of the vehicle we
Were
rented.
they injured?
Yes, Your Honor, and they settled out. I know she had
couldn't care less.
I believe she had
about
some
that. That's
pre-existing back injuries, and it exacerbated that when they were ran into the back of the vehicle.
what ran into the back of the vehicle.
Yes, Your Honor.
All right. As a condition of probation, you must serve 15 days in the county jail. And those will be on successive weekends. You go into the jail on or before 6 o'clock p.m. They release you at 6 o'clock p.m. on Sunday. And you get 2 days credit. And when are you able to begin that?
January 26th, it's Friday next week.
Friday week. You must report on or before 6 o'clock p.m. in the Jefferson County Jail Friday, January 26th, and each Friday thereafter at that time until you have been credited with 15 days service in the county jail. Do you understand, sir?
Yes, sir.
Also, we must include the restitution. Okay, why am I getting this judicial clemency? He's not eligible for judicial clemency for a DWI, is he?
No.
No.
It's always attached on the adjudicated forfeiters.
I know we normally do, but when you're not eligible for it, there's no reason to waste everybody's, I'm not going to sign it because he's not eligible for it. He doesn't get it. Then I don't have any kind of option under law. That's only for people who are eligible for judicial clemency, but you're not for a 49, a section 49 offense at DWI. I don't want the paperwork to get in there and then we inadvertently grant it because it would be a contrary to the law. Okay. Anything else?
No.
That is all. Thank you. Please see the probation officer.
You don't need to, you don't need to,
Here is this. Thank you.
I'll just have to bring this to the jail. That's the best. I'll send him a copy, but it's good.
Okay, yeah.
Next, Michael. I'm sorry, Jorge Lopez.
And has he signed up to?
She's trembling.
Yeah, she's gonna be my translation. When he speaks, well, yeah. Just translate. The judge says directly. So whatever he says, you say.
What's my own work name? Ashley.
Ashley, what's your last name? Hooks. HOOKS. And then whatever he say, you say. And then whatever he says, just say to the judge.
You finished
I'm
Well,
rounding
wasn't-
up.
with all those instructions? Are you Jorge Lopez?
Yes.
Do you speak some English, Jorge?
Mm.
Little bit?
He does.
You have to speak out. Yes, see? Yes, good, okay. Now, because you're not fluent in English, we have a lady here to translate. What is your name, ma'am?
Ashley,
You gotta have a full name.
Ashley Hooks.
All right. And are you fluent in English and Spanish?
Yes,
How did you become fluent in English and Spanish? Did you live in?
I was in Mexico 4 years and my ex-husband's Mexican.
All right. Have you ever been a translator in any proceeding before?
Yes.
Between for Spanish and English, English and Spanish? All right. Raise your right hand. Do you solemnly swear or affirm that you will translate correctly English to Spanish and Spanish into English in this proceeding? As the defendant, Jorge Lopez, is fluent in Spanish, you will, as I ask questions or if other parties have statements they make in English, please repeat those accurately and properly into Spanish. For the defendant, you will repeat his responses in English for all of us and the court reporter and me. Will you do that correctly? So help you God.
Yes, sir.
All right, lower your hand. Are you Jorge Lopez?
Doing some hair lookers. Yes,
Does the defendant waive a formal reading of this indictment in 23 CR 1027? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about April 9th, 2023, in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by discharging a firearm at or in the direction of a vehicle that was occupied by a person and you were reckless in what you did. Do you understand what you were charged with?
Yes.
If convicted, you face a term of not more than 10 years or less than 2 years in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable?
Yes.
An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, up to 10 years in length, fined $500. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this indictment charging you with this third-degree felony of deadly conduct? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of what this indictment states?
Yes.
I show you what's marked as State's Exhibit 1.
It's his signature.
I show you what's marked as State's Exhibit 1. Did you sign that document? Did you understand it and discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1 is tendered into evidence
No objections.
without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily being made by you. You know what you've been charged with. The indictment's been read to you, or you've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, and cross-examination of witnesses at trial. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, "So help you God." Is that so?
Yes.
Fine. Are you a citizen of the United States?
No.
You understand that a plea of guilty to a felony offense and being placed on deferred or unadjudicated probation or being convicted of a felony offense can subject you to deportation or affect your ability to remain in the United States and also to enter into the United States at later times. Do you understand that?
He said he is.
Is that yes?
Yes.
Do you insist on pleading guilty nonetheless? Also, And by. We, in the United States, we welcome all persons who want to enter the United States legally. But you're not supposed to come in as our guest and make a mess. This is a third-degree felony where you're shooting a firearm in the direction of another person. Do that in your own country. Don't do that here. If you have to do that, that's against the law. You are a guest. Treat us with respect and follow the rules we all have to follow. Do you understand?
Yes.
My relatives, I'm third generation American. They came, my mother's side, immigrated from Italy and Greece and from the Mediterranean. They followed the rules. They matriculated in and became wonderful citizens, law-abiding. None of them were ever arrested. They understood that America is not to be abused. We're supposed to live together peacefully. Can you do that? You didn't do it there. Anything further?
That's it. Thank you.
If not, again, I find that there is sufficient evidence from State's Exhibit 1 to find you guilty beyond a reasonable doubt. You have pleaded guilty voluntarily, knowingly, intelligently. I am going to follow this agreement and place you on deferred or unadjudicated probation for 10 years. You are fined $500. You must register properly with the immigration officials. That has to be done immediately. And you submit proof of your registration to immigration officials, to the probation office. That is a condition of probation. I want that done within 10 days. Do you understand? What's a term of probation? You were ordered to follow that as well. Bienvenidos, welcome, but don't make a mess and hurt other people. Anything else? That is all.
Thank you, Judge. Appreciate you.
Yes, sir.
Thanks, sir.
Where do you drive it?
What else? Do I have anybody else?